Good morning, Jack. I'm going to test your audio and the camera. Would you please turn on audio and camera so we can check if we can see you?
Hello, officer. Good morning.
I don't see you, Jack.
We could just move on back again.
Okay, back again.
All right, good morning, everyone. We'll go ahead and call the meeting to order. Ms. Linker, would you call the roll, please?
Commissioner Cardenas?
Yes, I'm here.
Commissioner Hatch?
Here.
Commissioner Wilson?
Here.
Chair Matich?
Here. Good morning, everyone, and welcome to our October Commission meeting. At the outset, I wanted to remind folks that today is the last day to submit your census responses. We, in coordination with the Secretary of State's office, have added a link to the Fppc's website. You can click on that link, access the census information, and submit your responses in that fashion. So please take a moment. It's important that we all respond to the census, so please do so. With that, we'll go ahead and open it up to public comment for items not on the agenda. Do we have any public comment on the telephone?
Yes, that would be me, Steve Petzold.
Good morning.
Are you able to hear me? Hello?
Yes, we can hear you. Please continue.
Okay. My name is Steve Petzold. I'm in Santa Clarita. I'm regarding a stipulation that was supposed to have been on the agenda today, 19.475. I had sent a letter earlier this morning hoping that I would be able to hear from Galena West as she gave you an update on 19.475. Unfortunately, it doesn't look like that's going to happen prior to me providing my public comment. So I do feel compromised in that area. So at the August meeting, I felt uncomfortable with the comments by Galena West that she was convinced that the foundation was not a multi-purpose committee because funds came from non-donor funds. I've placed a number of public records requests with the foundation to document her assertions, and I've been told those will not be available until after November 19th. I did want to make you aware that the College of the Canyons itself has an active investigation before the Fppc. It is my feeling that any stipulations regarding the foundation should come together with that of the College of the Canyons so that you can establish a nexus between the two. I've also put into the public record a letter sent by Jill Malati, the foundation president, that she sent to the trustees of the college. It's clear to me from two things that the foundation and a majority of the trustees are more interested in protecting themselves and the reputation of the college and the foundation rather than getting to the truth of the contributions that they made to the committee. Ms. Malati clearly doesn't understand the depth of the allegations which are against the foundation. She thinks that there was just administrative errors. I also want to bring it to your attention that there is a public records request put in against trustees McGregor and Alonzo for them to produce all emails between me, the complainant, and themselves. So I wish that you would have had Galena West update you on the status of 19.475 before I was forced to give this public comment, because it leaves me in the dark and into responding as to what her comments may have been. Thank you.
Thank you, Mr. Petzold. At the, I believe it was the August meeting, or the meeting when this stipulation was originally presented that you're speaking with respect to, we did pull that from the agenda. We requested Ms. West, at, I believe, your request and your additional submission of documents to take a second look at the case. We are in the process of doing that. As you, I hope, appreciate, we are a couple weeks out from the 2020 election. This is the busiest time for us in a 2-year cycle. Enforcement staff is working diligently to review the records you've provided, other records, and at the appropriate time, we will present this back to the full commission, so you'll have continuing opportunities to provide your comment. But thank you for your comments today. Do we have additional public comment?
Chairman, a question of the commenter. Have you received satisfactory response from the public records request? Or is that still outstanding? Mr. Petzold,
Yes?
did you receive the document
Hello?
did you receive the documents that you requested? This is Commissioner Hatch.
I don't know which document you've referenced. The only document that I've received is the letter that I requested from the college, from the foundation president, addressed to all the trustees. I have not received any documents other than that. I haven't received any documents from the foundation that were responsive to my request, and I was advised that I would not get any until November 19th is the date.
All right, thank you.
All right, thank you, Commissioner Hatch. I would note that we have
Will Delina West be giving an update on this? At the September meeting, she said she would be giving at least an update in October.
As I think I just clearly stated, Mr. Petzold, we are in the midst of evaluating the evidence, and at the appropriate time, Ms. West will provide an update. To ask her to speak about an ongoing investigation at this time in a public setting would be inappropriate. So at the appropriate time, she will present to us what information is appropriately subject to public disclosure, and at that time, you will have an additional opportunity to provide your comments.
Thank you.
Thank you. I would note that we have one digital public comment from James Albert in San Bernardino, and the comment is that he would like to request that we have more virtual FPPC workshops and trainings. I think I can confidently speak for majority of the commission. That is something that we agree with. We're working on that. I know our education outreach division is continuing to work on that. So thank you for your comment. We certainly were on the same page with that. If there's no further public comment for items not on the agenda, we'll proceed to item number 2. This is approval of the September 2020 Commission hearing minutes. Do any commissioners have edits or comments on the September 2020 minutes?
Move adoption.
I have a motion. Do we have a second?
Second.
Is there any public comment on item number 2? Hearing and seeing none. Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Moving on to items 3 through 9. This is our enforcement calendar. Do any commissioners wish to pull an item from the enforcement calendar for further discussion? Hearing and seeing none. Is there any public comment on the enforcement calendar? Do we have a motion?
So moved.
Second.
Motion by Commissioner Wilson, second by Commissioner Hatch. Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Moving on to items 10 and 11. These are notices of intent to present default decisions and orders at the November commission meeting. Ms. West, did you have anything that you wanted to apprise the commission of with respect to items 10 or 11?
No, I would just thank commission staff for moving these cases forward. They're difficult cases. There are a lot of paperwork, so I really appreciate their efforts.
Thank you. Do commissioners have any questions or comments on items 10 or 11?
There's a question that have either of these respondents contacted you?
No, there hasn't been any participation.
Okay, thank you.
All right. Any public comment on items 10 and 11? All right. Thank you, Ms. West. We'll now proceed to item 12. This is our repeal and amendment of regulations governing enforcement process. I believe Mr. Bainbridge, our general counsel, will be presenting this item to the commission. Mr. Bainbridge.
Good morning, Dave Bainbridge, the general counsel. Also, we have Jack Woodside and John Fazer on the phone. And in case I don't know one of the answers to some of these questions, they worked on drafting all these regs. But as someone who worked in enforcement for a number of years and is very familiar with the process and now is on the legal side of ensuring and that the commission itself follows the laws. I thought it'd be good for me to present these items, but you may hear John or Jack chime in if I don't know the answer to a more specific question. This regulation packet covers a number of the enforcement processes. The goal with this is to update and improve these processes. We've had some new technology employed by the Enforcement Division over the last few years, and we've also just had some experience with the regulations, some of which have been in place for a number of years. What we're trying to do with all these changes overall is to simplify the probable cause process, to clarify, particularly for unrepresented parties without attorneys, how the process works, what their rights are, and how the process plays into the entire enforcement process. Both on the legal side and on the enforcement side, we've noticed there's a fair amount of confusion about the process. So we're hoping to eliminate some of that confusion by simplifying the regs, so we don't have cases that end up in default like the ones we saw on the agenda today, because often a respondent who's unrepresented just is overwhelmed by the process and sticks their head in the sand, and they can end up in default. So we're trying to eliminate that happening. Another goal with revising our regulations is to expedite the process. Everyone involved typically wants a case to go faster, I guess, unless they're a respondent who's up for election soon. But everyone else has an interest in getting cases done quickly, regardless of what the result is. The goal here is to get disclosure. That's the ultimate goal of enforcement and the agency in general. And disclosure has a shelf life. So we have an eye towards expediting, particularly the probable cause process, because it's just the start of the administrative hearing process. The regs have been worked on by both Enforcement Division staff and Legal Division. So it's really been a collaboration between the two divisions. We've also had a number of comments from the public and from the commissioners. You may remember this was first up for pre-notice back in June, received a number of comments from commissioners and the public at that time. Since then, it's been heard in the Law and Policy Committees on 3 separate occasions, including I guess it was last week, feels like longer. So we've taken a lot of input since then, and so what I'll do is, we have a very thorough memo here, so I won't go through all of the changes that are being made. What I'll try to do is hit some of the significant changes that have taken place since the commission last saw this at pre-notice back in June, since it's obviously been a few months since they've probably thought about it. And then there's a few sort of hot button issues that I'll address. And then after I'm done, if there's questions or public comment, I'd be happy to take that. So, starting with Regulation 18360, this is the regulation that governs how enforcement complaints are received and processed and what information is made available to the interested parties as well as the public. We did this. This is largely being done as a result of the electronic complaint system that went into effect in late 2016. The ECS, as we call it for short, allows for the receipt of complaints electronically. In the past, they came in, until then, they mostly came in on paper, or if someone was very advanced, they'd send a PDF of a complaint. But by making them electronic, it makes it faster, it makes the process more efficient. It's allowed the Enforcement Division to make their files paperless. Everything is done electronically. And it also allows for the public to get access to public information through our website regarding enforcement cases. So what we've seen, what enforcement has seen, is that the ECS works well. So they want to revise the regs to more closely fit the practical process that they follow in handling complaints received electronically, and then also to expand the use of electronic complaints. While the reg is a repeal and adopt, it's not that big of a change in terms of deadlines and how the complaints are handled. It's just been rearranged, so it was easier, cleaner to strike it all out and start over. We haven't received any public comment on this regulation to date. We did have one item of discussion at the June meeting for the commission that concerned Subdivision E, which is how to deal with complaints. Actually, it's the situations where complaints can be rejected without notice to the respondents. Typically, if a complaint is filed against a respondent, they receive notice of it. We previously had said that we wouldn't need to provide notice for harassing complaints. Questions were raised legitimately. What does harassing mean? We talked about it, and I think what we really wanted to focus on is what we're talking about here is complaints that have no legitimacy, and it's clear on their face that there's nothing to them. A complaint against 25 public officials alleging mind control, something just clearly there's nothing to the complaint. We wanted to be able to reject those without having to go spend the time and resources to inform all of the people who are alleged to have committed these violations that are often aren't even violations of the act. The intent is still the same. I think the way we've revised the language here in the second half of Subdivision E more closely addresses that particular issue. And that language that I'm referring to says the enforcement chief determines, that the non-sworn or anonymous complaint fails to allege facts that could result in a violation of the act and may be rejected without notice. The other part of this is we added that these sort of complaints would not be included on the commission website. If respondents aren't getting noticed about these complaints, we thought it would be better not to have them on the website where they could be easily found by the public and you could catch an official off guard. There's also little to no public interest in clearly illegitimate complaints. So we thought that we weren't losing any disclosure by doing that, and it's a little fair for the person for the alleged respondent. So that's 18360. Do you want to stop after each one and take questions or comments, or do you want me to go through them all?
Why don't we stop with each one and ask commissioners if they have any comments on each one, and then we'll move forward.
Okay.
So do any commissioners have comments on the regulation Mr. Bainbridge just presented to us before he moves on? Commissioner Wilson?
General Counsel Bainbridge, thank you for that excellent summary. What would be the process of determining whether a complaint is illegitimate, if you will? Is that decided by you? Is it decided by you and several of your staff? Just if you just give me a quick idea how that would actually work.
Yeah, typically the process is when a complaint comes in, it's reviewed by a political reform consultant in the enforcement division. They then make a recommendation to the chief of enforcement on whether it is a complaint that they should open a case on to look into, maybe request additional information, or reject the complaint. So it would be a decision made by the chief of enforcement ultimately.
Okay. Now, would you have any input in that process at all, or?
No.
Okay. All right. Thank you.
Any other commissioners have questions on this regulation before we move on? Commissioner Hatch.
As to the criteria for determining what is an illegitimate complaint, or excuse me, a harassing complaint, do you think that that's sufficient in itself, or do you think there should be some guideposts for the staff and the chief to follow in making that determination?
We in coming up on how to capture what we were trying to get at, I think what we found is there are too many potential scenarios in order where we could actually describe with a lot of specificity what we're talking about. So the way we've drafted it leaves it for the chief of enforcement to make this determination because we couldn't come up with ways to make it more specific. I think it's something. It's the chief of enforcement knows these complaints, and these are, just to point out, these are non-sworn and anonymous complaints. So this wouldn't apply to sworn complaints. This is just those complaints.
Okay,
but
I'm sorry. Go ahead. I didn't mean to interrupt you.
No, if you're satisfied, I'm satisfied.
I'm satisfied. Thank you.
All right.
Thank you, Commissioner Hatch. If there are no additional commissioner comments, Mr. Bainbridge, would you like to continue, please?
Mr. Chairman,
Sure.
can I just interrupt for one little procedural thing? Was item 8 and 9 a part of the consent calendar?
Yes. I believe
Okay.
the consent calendar, as we articulated, was items 3 through 9.
Thank you.
Thank you.
Okay. The next regulation is 18361.1. This concerns administrative subpoenas. This was not before the commission back in June at the pre-notice meeting. We've added it since then. What it does, and this will make, it goes with some of the changes we've made to 18361.4, so I'll discuss it more when we get to that regulation. But what it does is require, when someone is responding to a subpoena from the Enforcement Division, if they withheld records that would otherwise be responsive to the subpoena for any reason such as confidentiality or privilege, they would provide a description of what these records are. It's often called a privilege log in other areas of the law. This is already required in the subpoenas that are sent out by the Enforcement Division. It just wasn't written down in a regulation anywhere. So because we're making a similar requirement on Enforcement Division attorneys when responding to requests for documents pursuant to a probable cause, that would make sense to also add what is already a process that's being used to the administrative subpoenas regulation. So I'll go on to 18361.4 unless there's questions about that one.
Any commissioner comments on point 1 before we move on? All right, Mr. Bainbridge, please.
Okay. Just to point out, there's a more recent version of this regulation that went up, I think it was middle of last week on the agenda. I guess it was late last week, as the result of some suggestions made at the Law and Policy Committee last week. And I'll highlight what those changes are. If you have the previous version, it's pretty much the same, so you should be able to follow along with the previous version, but just be aware there is a more recent version on our website, and it's labeled as updated. So this section is the section that controls the probable cause process. Probable cause is a preliminary internal determination of whether enforcement should initiate a formal administrative hearing, which is then done by filing what's called an accusation, which then triggers the Administrative Procedures Act and a formal administrative hearing. The probable cause is not an adjudicative proceeding. It's a question of whether to initiate an adjudicative proceeding. The basis for finding probable cause is a reasonable belief or strong suspicion is the language used. So, you know, it's a less than more likely than not, a fairly low standard, which is why we were trying to remember the last time a probable cause wasn't found on something charged. It's a very low standard. We couldn't come up. I think it's been 8-9 years since there was a probable cause where there wasn't actually a finding of probable cause for the allegations. Part of that has to do with the very low standard in the statute. The other part is cases, if there isn't sufficient evidence to meet the standard of probable cause, those violations aren't charged or those cases are closed. If there's any doubt about whether your case is going to get through probable cause, you're not going to charge that violation. So I just put this in, this is the context of what we're talking about when we talk about probable cause. It's governed by the statute 83115.5, which is what calls for this probable cause process. It's above and beyond what is required by the APA for an administrative hearing. So it's unique to the commission. That statute is pretty short. It doesn't even have any subdivisions, although I think they'd be nice to make it clear what it requires. But the requirements for that section are that a respondent receive notice of alleged violations 21 days prior to the commission considering whether there is probable cause to move forward with the case. It requires a summary of the evidence be provided to the respondent, and that the respondent have the right to be present for commission determination and to be represented by counsel at that determination. So those are the basic requirements for probable cause. What has evolved over time is our current probable cause process, which is what the commission has decided should be the procedural requirements to augment what is in the statute. We've found through experience, both as from the enforcement attorneys as well as the hearing officers, who are the attorneys in the legal division who hear the probable cause cases and make the determination, that there was room for clarification, room for improvement, again, with the overall goal of simplifying the process, expediting the process, making it clear. What we found is the majority of cases that go to probable cause involve respondents who are not represented. So our goal here was to make the process clearer for those who are not represented, fair for all, allow for a fairly quick, expedited process. So through time, we found areas where we thought we could improve the process. So I'll go through a few of these subdivisions. I won't go through the whole thing. One of the goals was to clarify what the standard is. The standard for probable cause was unnecessarily wordy and hidden in other sections. So we put that out front in Subdivision A. So it's probable cause exists when evidence sufficiently supports a reasonable belief or strong suspicion that the act has been violated. So that's now in Subdivision A. Subdivision B concerns what should be required in the probable cause report. Under the existing regulation, it requires a summary of all evidence gathered in connection with the investigation, including any exculpatory or mitigating information. The language we have recommended narrows that to focusing on a summary of the evidence that is relevant to the violations being caused or violations being alleged. In an investigation, you may have 6 allegations of violations. You investigate it, and 4 of them, you don't find that there's evidence of a violation. As currently drafted, it would seem to say you need to describe all the evidence you've collected, even the evidence that is irrelevant, because it doesn't result in a violation being charged. So what we've done here with this language is make it specific to violations that have been charged in the probable cause report. That's the evidence that needs to be described. In our initial draft back in June, you'll remember we had suggested deleting the requirement that you describe exculpatory evidence. We found that was, one, it's overly broad to describe all exculpatory evidence for the reason I just discussed. If there's exculpatory evidence regarding a violation, that violation is not going to be charged, most likely, and there'd be no reason to discuss evidence of a violation that is not being charged. So we wanted to, that was our original reason for removing that provision. But after some public comment and thinking about it more, there was concern that this would mean that exculpatory evidence wouldn't be included. Our assumption was if there was exculpatory evidence concerning a violation that's been charged, I think that's an unlikely scenario, but if there was, it would be in the summary of the evidence. But based on hearing the concern that would be left out, we decided to put it back in. The other piece that we did remove and have kept out is the requirement that they summarize all mitigating information found during the investigation. And this is simply because mitigating information is irrelevant to the probable cause process. The question at probable cause is simply, do you meet the standard for determining that a violation may have occurred and therefore justifying the enforcement division bringing an administrative hearing action? So the mitigating information we found often confused respondents, and they focused on telling you why what they had done was not as bad as it seemed, or providing other mitigating information that was completely irrelevant to the proceeding. So we thought by eliminating that, it would focus them on what the purpose of the proceeding was and eliminate just irrelevant information. So that is not in this current draft. I think it really confuses the matter, so we haven't added that in. So that is the description of subdivision, what is new Subdivision B, the probable cause report what has to go in the probable cause report, what the summary of the evidence required by statute would include. The next subdivision, subdivision C, just goes over the main changes. We've added this probable cause checklist, which we're hoping will help to facilitate understanding of the process and keep the process sort of on track. We modeled that somewhat after something that the APA or the Office of Administrative Hearings uses that we found is useful for all parties. Subdivision D concerns what the respondents' options are and what they can do in response to receiving the probable cause report. So a lot of this has been rearranged in our proposed version from the existing regulation, but there's a few change requirements that I'll hit real quickly. Again, the rearrangement is to hopefully clarify it and simplify it for particularly those people who haven't hired an attorney to explain it to them. One change we are making is in D2C, at the bottom of page 3. We've added and when I say change, I mean from the existing regulation, not from what was presented to the commission before. We've added a 75-day timeline. This is just to ensure that the probable cause process doesn't go on indefinitely. There was no sort of limit before, and there was no real way to move a case along if a respondent had requested probable cause but then stopped participating in the process. This is obviously much longer than the 21-day notice required by the statute, and it can be extended upon a showing of good cause. So if someone, for some reason, can't be available because of health reasons or they're just on a vacation and you hit the 75th day, the hearing officer at their discretion could extend it beyond the 75-day period. Next is...
Sorry, I was speaking out loud when I was supposed to be speaking to myself. It seems reasonable.
Okay. Next is section D3. This concerns the production of records. So the current version of production of records was put in place in 2011. This was, prior to that, there had been no requirement of document production for a probable cause. The statute just contemplates a summary of the evidence. It doesn't say a production of the evidence. But beginning in 2011, the commission began requiring the production of some of the evidence in the file, particularly evidence that supported or that the Enforcement Division relied upon to support their allegations in the probable cause report. As it specifically states, it wasn't a right to full disclosure of the enforcement file. What we found over time is that this standard could use some improvement. Back in June, we submitted a draft that made more minor modifications to that provision. And that one, what it did was made it talk about evidence to support alleged violations, which is similar to the current regulation, but it removed the mitigating or exculpatory requirement, which was in the previous version. Based on our experience and for reasons I stated before, this was cause for confusion and didn't provide anything that was relevant to the proceeding. Since that time, we received a lot of public comment about this provision. We received some comment from Law and Policy, and I believe at the pre-notice. So we've changed our approach to the record production. The version presented to the commission today would require a broader production than what the current regulation provides. It would be the entire file regarding a particular case as opposed to just the documents that support the allegations in the probable cause report, with a few exceptions. Those exceptions are records already in the possession of the respondent. This would typically be records that respondent has sent in response to a enforcement request. There's really no purpose in sending people back records that they've already sent to you. So if the records are known to be in the possession of the respondent, we wouldn't need to produce those. Another exception to the production of the entire file would be public records. This is a standard that we We borrowed from the Federal Elections Commission, which in their proceedings don't require the production of public records. At the last law and policy meeting, there had been some concern expressed by the commissioners, and I think it was good input that this could maybe be manipulated. What we had intended by this was essentially campaign records on SOS's website. SEI is available electronically. We didn't see any reason to take those records, print them out, and then provide them to the respondent if they were available. But we've sort of narrowed this since the last version, and this is one of the changes made from the version originally posted on the agenda. It's Subdivision, D3 at the bottom of page 4. So previously it said publicly available records. We've changed that to readily available public records to make it clear we're talking about not just a record that could be found somewhere on the internet, but actual public records. Says that term has a legal meaning. And then we added an explanation of what readily available public records would include at the bottom of that subdivision. All right, so those are two of the exceptions to productions. The other one would be confidential or privileged records. Obviously, we're not going to be producing those.
Excuse me. What you're guiding us off of, is that the one dated 9/23/2020?
No, there's a 10/15 version.
All right. That's what's in the agenda package. It's the 9/23. Thank you.
Yeah, and it's up on our website. And then the final exception is for subpoenaed records. These would be records obtained by the Enforcement Division from a third party via a subpoena. And the reason for not producing these records is there are statutes that prohibit the disclosure of subpoenaed records in certain circumstances. There are exceptions for that, particularly in the case of administrative hearings. However, the PC stage does not constitute an administrative hearing as that term is defined by law. So if these statutes would preclude enforcement attorneys from disclosing much of the information obtained by a subpoena, and the consequences for violating one of those sections are pretty severe. You can be charged with a misdemeanor and lose your job. So due to that, we thought it would make the most sense to exempt those subpoenaed records from the production at the PC stage. Now, once an administrative action or administrative hearing is initiated, the exception to producing those would apply, and the respondent would be entitled to them through the administrative procedures process. This just means they wouldn't get those records that may be prohibited from being disclosed by law at the time of probable cause. The next part I want to draw your attention to is actually a minor change that I would like to recommend, which is in Subdivision D3a. It's at the top of page 5 of the October 15th version. In this paragraph, it refers to documents and evidence. Documents in the first sentence, and then evidence in the second sentence. And then if you're looking at line 6, it says evidence again. I'm recommending changing this to the term records because that's more consistent with our new approach to the document disclosure. Evidence connotes some relevance. Here, since it's a production of the entire enforcement file on the matter, they may be records that may not technically be evidence. So we had changed it everywhere else. I just missed it in this subdivision. So I'm recommending changing those terms. Super fun stuff. Okay. And then I'm almost done with this section. Subdivision F. This is the provision that allows the hearing officer to receive evidence at a hearing or after the probable cause conference. The change we are proposing making to the existing regulation is allowing it to be provided after the probable cause conference. The reason for this is hearing officers often were asked by respondents, again, typically unrepresented respondents, if they could submit something after the hearing because they had a piece of evidence that they thought supported what they had said during their probable cause conference. And the hearing officers kind of wanted some guidance on how to deal with that sort of request. What we've added in response to public comment and some commissioner comment is the sentence you see, or the second half of the sentence beginning on line 21, which says, if the additional evidence is summarized at the probable cause conference. So the hearing officer could only accept additional evidence if that evidence is summarized at the probable cause conference. This way, it wouldn't be a backdoor to get evidence in that wasn't originally discussed at the probable cause conference. This is consistent with the statute, which simply requires a summary of the evidence. And we also added the provision that only evidence that confirms or disproves a statement made at the probable cause conference may be submitted after the conference. So again, no new evidence. This is evidence that was discussed at the probable cause conference. They just forgot to bring it with them to the conference. With that, I think that's all I have on this section, if there's questions.
All right. Do we have commissioner comments on 18361.4, probable cause proceedings? Commissioner Hatch.
Well, I had an awful time following this because I have the wrong version, and it just occurred to me that this is up for final adoption today, and the public who might or might not have wanted to comment on this are not availed of the current version.
Commissioner Hatch, I'm going to stop you for a second. My understanding is that this version was put up on the website. It is part of the agenda package, so the public has had access to it. Is that a correct understanding?
That's incorrect. My agenda package online has the wrong version. It's a 927, I think it is. My point is for final adoption, and the public, if they search, they have to be suspicious that the wrong material may be in the agenda package and then go search for it on our website. I don't think that's exactly what you call user-friendly. It certainly makes me concerned that we should maybe put this final adoption over the following month. Unless this is the only one, are there others that are going to fit this category?
Commissioner Hatch, we just checked the website and confirmed the fact that the updated reg has been up on the website for a period of time. I appreciate the fact that perhaps the version that you may have on your computer at the moment isn't that version, but as far as it goes in terms of the public having access to it, the public has in fact had access to it. I think that's an important fact to clarify in the record.
Not to just be disagreeable here, but I just opened this morning, this agenda off the web, and when I click that that proposed regulation, it gives me 9/23/2020. Now I'm not exactly a computer expert, but that may be the problem. But nonetheless, this is the agenda that was posted and it's on the web. I mean, this is, I can refresh it, but it doesn't look like much would have happened since an hour ago.
I have a question, Commissioner Hatch. Are you clicking the one that says updated 10/9/2020?
I'll have to back up and find out. I clicked current agenda. Sorry, 1 second here. Thursday, October 15th. Whereabouts would this be? Is it before the actual agenda opening?
Hi, Commissioner Hatch. This is Galena West. If you go to the website and you go to item number 12, then under item number 12, it has the memo, and then it has proposed repeal of regulation 18360. And then when you get to 18361.4, there's two versions, and one says dash updated 10920, and that would be the one you.
Let me just go back to where that was.
Sure.
I refreshed this to try and make sure that, okay. Oh, I see what you mean. 0.4 and then 0.4 updated.
Right.
That's regulation. My apologies to everyone that's been interrupted by this, and good thing I got pants on.
Thank you, Commissioner Hatch. Did you have a substantive?
I stand corrected. I'm fine with it. Thank you.
All right. Thank you, sir. Did other commissioners have questions or comments for Mr. Bainbridge on point 4? Commissioner Cardenas?
Yes, Mr. Chair, I just want to thank Mr. Bainbridge and staff for the change to, I believe it's 18361.4 D3. The clarification of readily available public records, I think, is most helpful, and in accordance with what I believe we discussed at the Law and Policy Committee meeting last week. So, thanks very much.
Thanks, Commissioner Cardenas. Commissioner Wilson, any comments? All right, Mr. Bainbridge, I did have a question for you, just to clarify. I'm looking at page 4 of the updated version, and I want to focus on the exception for records obtained from an administrative subpoena. That prohibition, and correct me if I'm wrong when I'm characterizing it that way, but my understanding is that the law, there's a government code statute that prohibits us from disclosing information contained in the private records obtained through administrative subpoena. Is that a correct understanding of the law?
Yeah, that's correct. Government Code Section 11181 and 11183 concern subpoenas issued by state agencies, administrative agencies, and it prohibits disclosure of the information obtained via subpoena except in limited circumstances. One of those limited circumstances is an administrative hearing, but at probable cause, we are not by definition yet at the administrative hearing stage where that exception would then apply and allow production of the records. So our recommendation would be that the respondents, if there are such records, would then have to wait until there wasn't a prohibition on our enforcement staff disclosing those subpoenaed records. This is consistent with our Public Records Act process, where we do not produce records obtained by subpoena even after a case is concluded. There's an AG opinion that we received a few years back validating that policy of not producing records obtained via subpoena because it is prohibited by the government code.
All right. So we're sure as a matter of law that government code provision applies to our agency. It's clear that it's a prohibition against disclosing information contained in those types of subpoenaed records at this point. And as an administrative agency, it would be unlawful for us to adopt a regulation that's inconsistent with a statute that governs our process. Isn't that correct?
That's correct.
All right. Thank you very much. Did any other commissioners have questions on this reg before we move on? All right. Go ahead and continue, Mr. Bainbridge.
All right. The next regulation is 18361.5. This section concerns administrative hearings, particularly if the commission decides that it would prefer to hear a a administrative hearing itself rather than referring it to the Office of Administrative Hearings to be heard by a ALJ. Most of these changes are just clarifying. The one issue I'd point out is back at the June meeting, we had proposed changing the requirement if the commission wants to hear a case itself rather than refer it to an administrative law judge. The current reg requires 2 or more commissioners to indicate a desire to participate at the hearing. We had recommended changing it to 3 to make it consistent with other decisions that would be made by the commission requiring 3 votes. But after hearing commissioners, I think a number of commissioners had expressed that they preferred it to be 2 or more commissioners that would then allow the commission to hear a hearing on its own instead of referring to an ALJ. So we've just returned it to, in this draft, it's the same as what the current rule is on when the commission would hear a case on its own. And then I had one more just typo that I found that we intend to change before we send this reg out. So it would be page 1 at line 20. It says he duty to hear. That obviously should be the duty to hear. So we'll be adding a T. So we would recommend that the commission adopt the regulation with that minor modification. Again, that's line 20 on page 1, adding T to what currently says he, because he's a word, so spell check doesn't pick it up as being wrong. That's all I had to point out on 18361.5. Again, we have a very thorough memo on this, so if there's additional questions, it's covered in there.
Any commissioner questions or comments on point 5?
Thank you for making it, restoring the 2-person division.
Commissioner Wilson?
I would just add, thank Mr. Bainbridge and all the staff that worked so diligently on these proposed regulations. But I would also add that if, and I would defer to the chair and the other commissioners, if you find any typographical errors subsequent to this hearing, that you be granted the authority to make those technical corrections.
Yeah, and for this sort of change, we do have that authority. Okay. I just would prefer to mention it on the record, so I like to call out our typos in public.
Actually, Mr. Bainbridge, before you continue, since we're talking about sort of stylistic changes, I know one thing that we've talked about before is ensuring that our regulations are written in a gender-neutral fashion, and I know you endeavor to do that as we go through. If you could take a second look through these regs before they're sent for final copy, though, because I think, in point 4 on page 3, there's a reference to he or she. So if you just take one final look through, I think those are the types of stylistic edits you should feel free to make after, presumably, we approve these.
Okay.
Thank you.
Okay. 18361.9 is the next in numerical order. This concerns the Commission's adoption of a decision by an administrative law judge. The prior draft from the June pre-notice meeting did not allow for oral argument by the parties to administrative hearing. This is after the administrative hearing has taken place. The Commission is then considering the recommendation of the administrative law judge for the case. The Commission has gone back and forth over the years on whether they allow oral argument in this situation or not. The June draft, like I said, did not allow for oral argument. The current regulation is silent on whether oral argument is permitted. After input from commissioners, and I believe some public comment, if I remember correctly, we have provided a provision that allows for oral argument by the parties, but does not allow for public comment. Much of the changes to this section were designed to ensure that the amount of information that is outside the administrative record that would come before the Commission would be limited, because obviously the decisions of the Commission have to be limited to what is on the administrative record. So most of these changes are aimed at ensuring that that sort of information either doesn't come before the commission or they don't consider it. However, we have put back in the opportunity for oral argument for both parties. That's all I have on that one. If there's questions.
Do you have, Commissioner, questions or comments on point 9?
Okay.
Seeing none, Mr. Bainbridge.
18361.11. This concerns default proceedings. There was no comments regarding this last time, and there have been no changes, so it's the same as what you saw in June. This is just ensuring that respondents have every opportunity to receive notice of a proceeding before it ends. So we're requiring personal service of default documents as opposed to certified mail.
If there are no Commissioner comments, Mr. Bainbridge.
And then lastly is section 18404.2. This section concerns administrative termination. Administrative termination is a procedure that was put in place a few years ago that allows the Enforcement Division to close defunct committees. We have criteria for when a committee is eligible to be administratively terminated. Essentially, it's when the committee has no activity and little or no money left and is really an inactive committee so we can get them cleared off the books. They won't have filing obligations and SOS doesn't have to keep track of them anymore. What we've done, the amendments here are just adding some additional justifications for an administrative termination that we've over time realized we should probably have this as a reason to terminate a committee, namely death or incapacity. So that hasn't changed since pre-notice either.
All right. Thank you, Mr. Bainbridge. Do we have any Commissioner questions or comments on 18404.2?
The item on page, excuse me, on line 20 of page 1, on the evidence of deceased or incapacitated, what would sufficient evidence, is that, I'm not a lawyer, so is that a low standard or?
Yeah, I think typically that would mean a death certificate or a doctor note or something. Maybe. Do you have anything else?
Okay.
Obituary.
Thank you. I appreciate that.
Commissioner Wilson.
Okay. A related question. Let's say it's someone who is noted in the community, and there's a press story indicating that person had unfortunately passed away. Would that suffice, or would you have to wait to actually get the death certificate or some other kind of official verification?
Galena West. So what we do for press notifications is we make sure it's a legitimate press, and if there is any doubt, we generally confirm with someone else involved in the committee. But yes, if it's a legitimate media outlet, then we accept that.
I just want to clarify that you have that discretion. Thank you.
I have a question on the administrative termination reg, on that provision, line 20 that we're talking about. I think this, the question from first Commissioner Hatch and the comment by Commissioner Wilson, it does suggest to me that if we're going to use a term or a phrase like sufficient evidence, that perhaps we might want to add some clarifying language to sufficient evidence, including but not limited to a death certificate or a verifiable press account. Just in fairness to the regulated communities, that there are at least some examples. I trust you, Ms. West. I trust the Chief of Enforcement to be reasonable under these circumstances, but I also feel like part of the reason we have the regs is just to make it clear. So how would you feel about adding just a very short clarification to that provision?
I would actually recommend against it just because of the incapacitation portion, because when you're speaking to someone about their loved one having dementia or being at the end of life hospice, you're not really at that point where you want them to provide you with, medical records, and you want to be able to take their word for it that they're on hospice and unable to participate. So I would want to keep it a little vague for situations like that where you have the complete understanding that this is what is happening. And I would remind you, this is just for administrative termination. These committees can reopen for any reason. So this isn't a final decision by all means. It's just a way to help these different committees. So I would prefer to keep it a little more open.
How do you feel about the word sufficient? Is it necessary?
No, I think just evidence is fine.
All right. If you think sufficient is unnecessary, I would support the deletion of the word sufficient and leave it to the Chief of Enforcement to obtain whatever evidence she determines to be the necessary. Commissioner Hatch, did you have additional comments?
Oh no, I just if that word's not doesn't add meaning, I just can get rid of it.
Okay. All right. Seeing no objection from other commissioners, Mr. Bainbridge, why don't you delete the word sufficient in front of the word evidence on line 20 in 18404.2. And then taking a step back, I had a question for Mr. Bainbridge. What is the effective date of these changes should we adopt them today?
We can choose an effective date. The default is 30 days from when SOS receives them from the Office of Administrative Law, so I can't give you an exact date until Office of Administrative Law processes them, because that then starts the 30-day clock. But if we'd like to choose a date, we certainly can do that.
In light of the fact that this package of regulations deals with a process that folks in the regulated community have to abide by, and that we abide by with respect to our enforcement cases, I do think in this circumstance, putting a date certain as the effective date makes sense as a policy matter. And I would propose that be January 1st, 2021. So all these new regulations on the enforcement process would apply to all probable cause reports served on or after January 1st, 2021. Do the commissioner?
I would concur with that.
All right. Thank you, Commissioner Wilson. Commissioner Hatch, thank you. Commissioner Cardenas, does that give you any heartburn?
No, that's not what's giving me heartburn. Thank you very much.
All right, excellent.
Something for breakfast?
Yeah. All right.
And then, Chair Matich, just on that point, given that we are in the midst of a pandemic, the January 1st date would give the regulatory community and all interested parties ample time to review these regulations that have now been modified. Thank you.
Correct. All right. If there's not additional commissioner question or comment on the package of regs, I'd open it up to public comment at this time. Do we have any public comment on the phone on item 12?
Yes, Mr. Chairman. Can you hear me? This is Chuck Bell from Bell McAndrews and Hilltack.
Yes, we can. Good morning, Mr. Bell.
Good. Thank you. Good morning. How are you? I'm speaking not on behalf of the law firm, but in support of and on behalf of the CPAA Enforcement Committee, which most recently submitted a comment letter yesterday, and largely going to confine myself to commenting on that. First, just thanks to you, Mr. Chairman, and the members of the Law and Policy Committee, and the General Counsel, Mr. Bainbridge, for the work and willingness to entertain comments from the public on this. I think we have narrowed our remaining comments to the ones that are set forth in the October 14th letter from Ellie Abadali. And it concerns the probable cause process, and in particular, the point that we've been making throughout this is that the probable cause process, while it is unique to the commission, was really enacted back near the beginning of the commission's existence. I think largely because of the political nature of the FPPC's investigative and enforcement processes, and the importance of trying to give as much due process as could be given to that. A lot of us who are in this participate in these as well as administrative hearings, but we have had one eye on the probable cause process as it concerns unrepresented parties. And so really the focus we've had has been on ensuring that any exculpatory or mitigating information be provided. I agree with Mr. Bainbridge that while many people will present mitigating information, let's just focus on exculpatory information. I think there's a fundamental issue here for the commission to try to ensure that its processes really do afford due process, and that indeed exculpatory information ought to bring to an end any investigation, any probable cause, and certainly any prospective administrative hearing into a violation for which there is exculpatory information. And so the objection that we have to the current draft of the regulation is that we think that it does continue to allow for the exculpatory information that's in the possession of the enforcement staff not to be provided if that information has been obtained through an administrative subpoena. And mind you, on administrative subpoenas, anyone can request that you administratively subpoena them for information, and it might even involve exculpatory information. Would the commission staff catch that? And I guess the question is who makes the determination that it's exculpatory? Frequently, counsel on both sides have different views as to what may be exculpatory, and to deny the opportunity to counsel or even an unrepresented party to say, look, this is exculpatory information. This count should not go forward. This issue shouldn't go forward to what can be a very expensive process for both the unrepresented and represented. So we think that the 11.383, 11.388 process in the government code that relates to agencies not providing information that they've obtained really has to also look back at what the underlying question is, and it's intended to prevent abuse of privacy. And so I don't know that a blanket exclusion from providing exculpatory information, if it has been obtained through an administrative subpoena, necessarily ends the question for commission staff. It's the nature of the information that was provided intended to preserve privacy, or is it has just been submitted because the party from which the information is being obtained by subpoena for whatever its own reasons may be requires that to be obtained. There is a legal process that is permitted under that law to test whether or not information is subject to that provision. We're not asking the commission to blithely ignore the law or ignore the possibility that they could either confirm with the party that provided information that that is the kind of privacy information they would want to object to and wouldn't want to be subjected to having to go into a collateral proceeding to defend their privacy interests. So that's our view on that, that the exception that you've created is broad, and there ought not to be a possibility in this process that exculpatory information is not provided to a party that's the subject of a proceeding. The second point I'll just go over briefly, and that is we do think there ought to be an opportunity, if there is a discovery dispute, for the hearing officer at probable cause stage to address that issue. Yes, it complicates the procedure a little bit, but neither party ought to have an opportunity to either present or not present evidence that's subject to dispute without having it resolved by someone. In other words, the Enforcement Division ought not to basically unilaterally have the final word on that, as it is a party in the proceeding. So those are my comments. Again, we appreciate the efforts of the Commission staff and commissioners on this. We know you've devoted quite a bit of attention to it. We think a little further tweaking is appropriate and lawful. I appreciate the chance to comment.
Thank you, Mr. Bell. I appreciate your comments. Do we have additional public comment on the line for item 12?
Good morning, Commissioners. This is Mike Colombo. I'm an attorney at the law firm Nielsen Merksimer, where I've both filed and responded to enforcement complaints. Thank you for the opportunity to address the Commission on this important subject. I shared the same concerns expressed in the letter you received from the California Association of Counties and the CPAA comments that you have also received by letter and through Mr. Bell's comments. I just wanted to add a couple of points. In this echoes what Mr. Bell was saying. Staff points to section 11183 and asserts that it broadly prohibits the disclosure of any subpoenaed information. However, the plain text of that code is limited to prohibiting disclosure of, quote, the confidential or private transactions, property, or business of any person that is obtained by subpoena. So the text is limited, and as Mr. Bell explained, there is a way for that process to play out that further supports that that provision prohibits disclosure of confidential or private information only. To the extent that subpoena documents contain exculpatory information that is in a document that has sensitive information as well that may implicate 11183, there may be ways that the exculpatory information can itself be provided without publishing the other sensitive information, and this is routine and legal and agency proceedings in California and throughout the country. Staff contends also that exculpatory and mitigating evidence is not relevant to probable cause, but paradoxically also asserted that it will not seek probable cause if it has exculpatory evidence, and those two propositions are irreconcilable. This may beg the question that I think no matter what the Commission does will be an issue going forward, if there's even a consensus on what exactly we mean by exculpatory or mitigating evidence. Virtually every reasonably disputed case should have some exculpatory evidence somewhere. For these reasons, I urge you to modify the rules to require the disclosure of evidence regardless of how it's obtained, and to permit hearing officers to address discovery disputes. And finally, because these changes fundamentally affect the due process rights of all parties, and those parties have been consumed with an election less than 3 weeks away, I urge the Commission to hold this rulemaking over to allow greater public participation than it already has. But I do appreciate the Commission's consideration of public comments and the modifications that it has undertaken. And thank you for your time.
All right. Thank you, Mr. Colombo. Are there additional public comments on item 12 at this time? All right. Mr. Bainbridge, I'm going to sort of put you on the spot here on the issue of the administrative subpoenas. If I'm understanding the public comment and sort of with respect to administrative subpoenas, what I'm hearing from the regulated community or the representatives from the regulated community is they would want us to take the records we obtained from administrative subpoenas and parse through them, identify the private or confidential portions of those records, and presumably redact or not release those, but provide what is not redacted, the non-public portions. And when I read the government code provision, I think we have to go by the plain language. I appreciate Mr. Bell's comment about what the intent may be or may not be, but the first step, of course, is looking at the plain language. And 11183 provides that an officer shall not divulge any information or evidence acquired by the officer from the interrogatory answers or subpoenaed private books, documents, papers, or other items described in Subdivision E. It's private books. All information contained in a private book under that language would be withheld from disclosure prior to an administrative hearing. And the issuance of a probable cause report is not the beginning of an administrative hearing. So we are squarely within the ambit of 11183. And what I struggle with is it clearly states, the plain language is private books, records, documents, information, et cetera. It doesn't say the private portion. It doesn't say the records and then you may redact what you think is private. It seems to be much more broad than that, presumably because later on, once the APA kicks in, you have a trained, qualified administrative law judge who can then determine what is or is not private or confidential, redact those portions, and allow for the production of what's left. That's my reading of it, but I'd like you to respond to those public comments and assure us that we're on the right track with that.
Yeah, I agree with your reading of it, and what Mr. Bell and Mr. Colombo said is correct. It is private records or books. I think this discussion itself is showing how difficult a determination that may be, what that term means. There's very little guidance in the law. We do have a AG opinion that I mentioned earlier that says checks that we receive, personal checks, are considered private, but the term isn't otherwise defined much. I point this out to say if the enforcement attorneys were required to make this call, there's lots of instances where it would be hard to tell if something would be considered private by a judge. So if you're asking them to make this determination, facing potential misdemeanor charges and losing their job, I think it's very difficult to ask enforcement attorneys to decide to make this decision. Now, after you get past the probable cause process, this prohibition no longer exists, and these documents would be disclosed in their entirety if they were relevant to the proceeding. So our feeling is they're not being denied due process in any way. They just would not get these documents at this point to the extent they would exist. Again, exculpatory documents disproving a violation seem unlikely to be in the file for a violation that's been charged from the beginning. But if they do exist, the parties would receive them. They just wouldn't receive them at this stage because there's a statute that in many instances would prohibit the disclosure of this information. Yes, there may be circumstances where a subpoenaed record wouldn't qualify as private, but there would be many circumstances where it would be hard to make that determination. And at the PC stage, there's nobody there to make that determination other than attorneys here at the agency who don't have any authority to make that determination. Whereas once you get into the APA, you have hearing officers who are trained and have the authority to make determinations on what evidence would need to be disclosed, plus the evidence would now fit within the exception that would permit disclosure because of that you have an administrative hearing. So I appreciate the concerns about parties not receiving potential theoretical exculpatory information obtained from a third-party subpoena, but they would receive the information.
Thank you, Mr. Bainbridge. Do other commissioners have questions, comments for Mr. Bainbridge?
Prepare to move
right.
for adoption.
All right. Well, I was just going to mention this was, I think it bears repeating, first brought to us way back in June. It's been heard in Law and Policy 3 times. And at the October meeting, Commissioner Cardenas and I have recommended adoption by the Commission. So, Commissioner Hatch, I hear you.
Thank you.
Making a motion?
I do.
All right. Do we have a second?
I think sorry to interrupt, but I think we should make it clear in the motion that we're adopting it with the revisions discussed here today, as well as the adoption date of January, or the effective date of January 1, 2021.
You modify my motion to conform to that advice.
All right. So then the motion on the table is to adopt the regulations, proposed regulations contained in item 12, subject to the changes we discussed today, and to be effective January 1st, 2021, applicable to any proceedings in which probable cause report was issued on or after that date.
Second.
All right, we have a motion and a second. Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. All right, we've been going for almost 90 minutes here. Do we want to take a 5-minute break? Or shall we continue, Commissioners?
For the chair.
All right. All right, I don't hear anybody asking for a break, so let's keep on going then. Proceed on to item 13. This is our Commissioner Code of Conduct. This is something that Commissioner Cardenas, along with our staff, has been working on for several months. This was another item that came to Law and Policy in October, and which comes before us today with a recommendation for approval from L&P. I think today, in addition to Mr. Bainbridge, we have Commission Counsel Mr. Cornwall with us to present this item. Good afternoon, or good morning still, I guess, Mr. Cornwall.
Good morning, Chair Matich and Commissioners. Today I'm presenting for discussion and adoption the Commissioner Code of Conduct and several accompanying documents, which would update and replace the Commissioner Manual. And as Chair Matich just mentioned, the Law and Policy Committee recommended approval of the Code of Conduct with one minor change last week. So as a quick recap, this process began in October of last year when, upon the Commission's request, staff presented a review of chapters 3 and 4 of the Commissioner Manual and identified that the document contained several ambiguities with respect to the information it conveyed. In some instances, it was unclear whether information should be considered an express statutory requirement, an adopted policy, a recommendation, or simply a legal interpretation or discussion. You might remember we had a document that was sort of color coded, and there were several it kind of looked like a Jackson Pollock several colors on each page. So in the following months, staff responded to requested revisions and identified other areas for improvement and clarification. Ultimately, we began working on an updated Code of Conduct that would resolve the aforementioned ambiguities. With that in mind, staff has drafted the Code of Conduct with the goal of clearly distinguishing express legal requirements, commission policies, interpretations and analysis, and best practices. I can quickly walk through the various sections of the Code of Conduct and the accompanying documents. Would you like me to pause after each section or just proceed through it?
Where was
go
the
ahead.
Greek? Sorry.
Go ahead, Commissioner Hatch. What were you going to say?
Where was the minor change that was done?
So the one minor change, which has been included in the updated version that's on the agenda website, is that in discussing the political activities, the section 83105.
Page in line?
Sorry, let me pull this up. So if you were to go to page 3 of the updated Code of Conduct, you would see that under section 2, political activities, the last bullet point, it's been added to more expressly clarify that under section 83105, commissioners are prohibited from seeking election to office, not just while they serve on the commission, but even if they were to resign early prior to the end of their term, they would still be prohibited from running for office. We also, per the committee's request, we added a footnote sort of further explaining that this was amended in 1986 in direct response to that type of situation. So that's the one change that's been made since last week.
Thank you.
So just proceeding through the document, the first section of the Code of Conduct, it includes a portion of the Commissioner's governance policy, which we've also attached as a standalone document. But this section specifically pertains to Commissioner conduct. And that's been updated since the governance policy was first adopted in December of last year. It's been updated to include the language previously identified by Commissioner Cardenas, which would require commissioners to, at all times, meet high ethical standards that exceed legal minimums. So that change has been made not only to the Commissioner Code of Conduct, but the equivalent section in the standalone governance policy document. And as just mentioned, the second section pertains to political activities. As just explained, there has been one minor update to more expressly clarify what is required under 83-105. And we've also added a section on best practices recommended by legal staff in an effort to, again, more clearly distinguish what is expressly required versus what is recommended, as from the legal division.
On that point,
Mm-hmm.
my eyesight's not the best in the world, but I appreciate the best practices being highlighted, but gray on black is more difficult to read. So when you get to your final, you might want to change the color or something.
No problem. We can change that. So this was done to, more expressly delineate what is required under 83-105 and legal staff's sort of legal analysis of 83-105 and the consequential recommendations by staff. The following sections relating to statements of economic interests, gifts, honorary and travel, conflicts of interest, and ethics haven't been significantly modified from the respective version that was included in the Commissioner manual, other than updating them for clarification or to provide additional information. So, for example, the Commissioner manual, the section on gifts, it wasn't clear whether these were additional policies adopted by the Commission, when in fact they were actually just reflections of what was already prohibited under the Act. Mm-hmm. And with respect to the additional information, the Commissioner manual didn't include much of an explanation with respect to conflicts of interest. So we updated it to include sort of just a brief primer on section 87-100 and 87-103. And again, these are just, including the express legal requirements under the Act. The following section on ex parte communications has also been significantly revised. In the Commissioner manual, again, it wasn't clear whether these were to be read as legal requirements, commission policies. There was some question as to the sufficiency of some of the legal cases that were cited in support of the discussion on ex parte communications. So we went through and have updated the section to more clearly inform commissioners by essentially incorporating the express language of the APA and what's required under the APA, only updating the language to more clearly fit the context of the commission. So rather than referring to a specific or a general officer, we refer to commissioners in the section. So moving on to the accompanying documents, as I mentioned, the FPPC governance policy was adopted in December of last year. And
Before you
again,
change documents, I had a question on, page 6. Item number 3 talks about within 30 days of leaving office that you're supposed to file a Form 700. And I'm mindful that in past times, there's a number of commissioners have been held over indefinitely until a replacement was appointed. And as I'm reaching the latter stages of my term, this kind of jumped out at me. Is it as a matter of course, do you notify a commissioner when he's been replaced, when he's in a holdover? How do you determine when this 30 days starts to run in that particular instance?
Commissioner Hatch, I'm not entirely sure. I hadn't sort of encountered that while I was preparing this. I would presume that you would not be required to file a Form 700, until the commissioner has in fact been replaced, at which point, I'm sure that we can make sure that there is some sort of internal policy in place to inform them as soon as possible that, this has been addressed. But I'm not entirely sure. So I can get back to you on that.
Thank you. It'd be nice if we have at least an internal policy that says you notify me in writing and put in an effective date that I can rely on for compliance with the Form 700 obligation.
All right, hang on, Commissioner Hatch. You raised a question. I think Ms. West may have some gloss to add to what Mr. Cornwall mentioned.
Okay, thank you.
Hello, this is Galena West. So basically, the appointing authority lets us know when there's a new appointment, especially for holdovers. We're in direct communication with you, so it wouldn't be surprised. And then we have this terrific SEI unit that is in constant communication with you about filing your leaving office statement and making sure that it gets filed timely. So that's what the internal process is. That they worked, like for instance, they worked with Commissioner Hayward when she left and made sure that she filed her leaving office statement on time.
Okay.
No surprises.
Yeah, that's good to know. I just was a little concerned that, a lot of times when new people come on, I don't know until the PR thing. And so it just raised the issue in my mind, what date is the date, the 30 days?
Yeah, we'll definitely communicate that.
Thank you.
When that occurs.
Thank you for the clarification on that point. Moving to the governance policy, again, this was included in its entirety in the commissioner manual and is attached here as its own document. Again, largely identical to the policy adopted in December 2019. Generally, it's just been updated to fix minor typos, as well as add the high ethical standards language we already discussed. The Fppc Overview, that includes much of the information that was included in chapters 5, 8, and 10 of the Commissioner Manual. And this document essentially just reorganizes and consolidates the information as a standalone document. The additional resources document includes additional informative material, such as the Attorney General's handy guide to Bagley Keene, as well as links to FPPC's enforcement division materials, which was done, the commissioner manual previously had its own section on enforcement division policies, but we figured that in, attaching or links to the FPPC's enforcement division guide, it might be able to commissioners more up to date. For example, with all of the updates to the enforcement process that occurred today, we didn't want to have to update and send out a new code of conduct or each time that something is changed in the enforcement process. And then lastly, the history of the Political Reform Act that preserves Appendix B of the Commissioner Manual with minor updates to the language, as well as a new section on the Disclose Act. So overall, staff believes that this code of conduct improves upon the Commissioner Manual, particularly with respect to clarity, making sure that it's clear to the Commission what is expressly required of them under the Act and other relevant laws. Staff recommends the Commission adopt these materials, but is also prepared to incorporate any additional revisions per the Commission's request. So if there are any questions, I'd be happy to answer them.
Thank you, Mr. Cornwall. And again, I want to thank you for your work over these several months with Commissioner Cardenas on this. Commissioner Hatch, you have a question?
Effective date?
The effective date? I drafted, I think there's a portion of the, there's a reference in here to adding the, I drafted it with the assumption that it would become effective upon adoption. So I can add something to the cover page and send it out in an update that clarifies the fact that it would become effective essentially immediately.
Well, Commissioner Hatch, if I may, I think this is probably a more nuanced conversation because the package of documents before us includes things that have been previously adopted by the Commission, and the task primarily that Mr. Cornwall and Commissioner Cardenas were doing, we're going through and trying to reorganize and clarify the contents of those policies to make it easy for commissioners to understand the legal requirements, the previously adopted rules that we impose upon ourselves, and what are best practices that we're all agreeing to. So I just want to, the vote today to adopt this package, I want to be very clear. We have had a code of conduct in place for several months now. We've had a governance policy in place for several months now. So this is more of a reorganization and presentation of those documents, to my mind.
Sorry, thank you for that clarification. Yes, with the goal of having included just essentially what is expressly required or what the Commission has already adopted, this is in many ways a restatement of what has already been in effect.
Correct.
Thank you.
All right, do we have additional Commissioner questions or comments? Commissioner Wilson?
Yeah, I would just concur with what was just stated by the chair and staff. As the newest commissioner, this code of conduct and other reference material is consistent with the orientation and briefing that I received when I first joined the commission. So thank you.
Thank you, Commissioner Wilson. Do other commissioners wish to comment?
Mr. Chair, if I might, I just want to reiterate, as I stated in our Law and Policy Committee meeting last week, I'm sure on behalf of all of us, our undying appreciation to Messrs. Bainbridge, Fesser, and certainly Kevin Cornwall and whomever else may have made a contribution to really yeoman's work over the last year or two to put this together. Before I go any further, I'd like to point out I'm afraid I just violated, I just violated this myself. Full disclosure, as you may have noticed a few seconds ago, my dog happens to be with me, and of all time, she's choosing this moment to try and be affectionate. And I was trying to get a hold of someone in my household to please liberate me of this beloved canine. Having disclosed that, I want to thank Mr. Cornwall for, among other things, elevating with such cultural refinement in his introduction today, the tenor of our discussion today with the reference to the late Jonathan Pollock, because the prior iterations of the various documents which now comprise a robust and clear code of conduct and governance policy did represent the American abstract expressionist movement, and that are left a little bit too much to be interpreted. This is clear, and it is as it should be. It's aspirational. It invites, in fact, it compels commissioners to not meet but to exceed legally required minimal standards. That's the spirit of the Political Reform Act of '74. That's what the people deserve. And I want to congratulate Mr. Cornwall and everybody else who worked on this for capturing that. And I look forward to all of us adhering to this immediately. Mr. Chair, thank you very much.
Thank you, Commissioner Cardenas. And again, thank you, Commissioner Cardenas, for your work on this. I think you're understating the role you played in this. So thank you, sir. Commissioner Wilson?
Yeah, I would be remiss to not recognize Commissioner Cardenas for his outstanding leadership on this issue, and notwithstanding the violation of the code of conduct by his canine, there was a statement that Mr. Cardenas or Commissioner Cardenas made when I first joined the commission, and when he stated that the law should be the floor and not the ceiling. That's a theme that should guide all of us moving forward. So thank you, Commissioner Cardenas.
All right. At this point, let's go ahead and open it up to, is there any public comment on the telephone for item 13? This is the Commissioner Code of Conduct. Hearing none and seeing no digital public comment, do we have a motion to approve?
So moved.
Move it, sir.
All right. We have a motion. We have a second. Ms. Lenker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Excellent. Thank you. And again, thank you very much, Mr. Cornwall. Appreciate it. All right. Next up, item 14 is our legislation report with our legislative counsel, Ms. Nakano. Good morning, Ms. Nakano.
Good morning, Mr. Chair, Commissioners. AB 2151 was signed by the governor and chaptered, and last week our office submitted a budget change proposal to the Department of Finance that was based on the fiscal estimate that was detailed in last month's commission meeting. I'll give a very brief overview of the budget process, or the process for getting that funding. If the Department of Finance approves the budget change proposal, it will be included in the governor's budget, which is released in January. And if the proposal makes its way through the budget process and into the final budget bill, funding will commence with the 21-22 fiscal year starting in July. Last month, the Commission also approved the proposed legislative slate for next year, and since then, staff has been researching and drafting language for those proposals, and is beginning the process of reaching out to potential authors. The legislature is set to reconvene January 4th. As of now, we don't have a legislative calendar for the rest of the year.
All right. Thank you very much, Ms. Nakano. Do commissioners have questions or comments for Legislative Counsel Nakano? Hearing none, is there any public comment on item 14? Hearing none. Thank you, Ms. Nakano. Look forward to hearing your update next month. All right, we'll proceed then to item 15. This is the update of from our Law and Policy Committee earlier this month. Commissioner Cardenas and I are seated on that committee. We heard, as we alluded to earlier, interested person feedback on the regulations for the enforcement process and recommended adoption. We also heard interested person feedback on the pre-noticed amendments to the regulations governing our streamline and warning letter program. I thought that was very helpful to receive that feedback and staff input, and so that is an item that will come back to the Commission in future months. We took up the Commissioner Code of Conduct, as I mentioned before, again recommending full adoption to the Commission, which we've done today. We also received an update from staff on their behested payment research, with a particular focus on the process for how state official behested payment reports are filed. Staff recommended to us that we pursue legislation which would streamline that process and allow for the electronic filing of behested payment reports by state officials directly with our agency, as opposed to the current two-step process where they file with their agency and then sometimes it is forwarded to us electronically, other times it is forwarded in hard copy. So we're looking for ways to make that process more efficient and more streamlined. My anticipation is that Ms. Takano will present that concept to us next month as something for us to consider adding to our legislative package for next year. So commissioners will have an opportunity to vote on that next month. We received a legislative update, which is along the lines of what we just heard. And we also, at Commissioner Cardenas's suggestion, we have asked staff to present to the Law and Policy Committee some new ideas for how we might devise a process for setting the part-time commissioner compensation. There were some questions raised about that, and so next month we'll receive a report from staff on different options there. Commissioner Cardenas, did you have anything you wanted to add to that description?
No, Mr. Chair, I thought that was a very full and faithful recitation of what we did last week. Thank you.
Excellent. Thank you, sir. All right, do we have other commissioner questions or comments on the work of the Law and Policy Committee? Hearing and seeing none, any public comment on item 15? If not, we will go ahead and proceed with item 16 then, which are our executive team reports. We'll go ahead and begin with Chief of Enforcement West, Enforcement Division report.
Good afternoon. Let's see if I can start video. So basically, we are slammed with the election, and so I wanted to give you some highlights as to what's going on. And so what was asked was also to talk about some trends that we had seen. So we have 203 pre-election referrals that we've received from the Proactive program, where we reach out to all the counties and all the cities with 100,000 or more population, and then they respond to us with their non-filers, and then we reach out to them. So we have 203 that we're currently working on, and 6 have already gone to attorneys for contact and possibly injunctions to make them file before the election. We had less participants this year when it comes to the different jurisdictions, but we anticipated that because a lot of the jurisdictions are on limited hours and don't really have the resources to pursue as vigorously as they have in the past years. And our complaints are up. We've had 712 complaints received since the primary, and 725 referrals received. So it's a large workload since the primary. And then AdWatch, we had 126 submissions, and which is right on pace with the 2018 election as well. The trends that we've seen mostly related to the ballot measure campaigns. The primary for AdWatch, interestingly, was mostly print ads, mailers, and signs were what most of the AdWatch complaints that we received were. And now with the general, we're about 50-50. So the electronic media and social media pages, text message disclosures. We're receiving more and more and more complaints and ad watch submissions on the electronic media. Lots of ballot measure allegations, and then also we have been receiving a lot of allegations where someone is running for office and they have combed through their old reports from the 2016-2018 election and submitted complaints about those election cycles. So it's about a current election, but it's about past activity. So it's more difficult to discern how to rank it in the how hard it needs to be expedited. And that's about it. We did also expand the ad watch. We sent out a press release saying that we are encouraging the reporting of election-related communications by public entities, and we have received an uptick in those since we've released that public information in the news release. And then, and giving you a brief update, I was required to give an update on the College of the Canyons case, and that is still in full investigation. And 3 weeks ago, approximately, another complaint was filed on the same party, so we are incorporating that and including it into the investigation. So as more complaints come in, it will lengthen the process. I think that's everything for Chief of Enforcement.
Thank you, Ms. West. And just let me take the opportunity to thank you. Enforcement Division staff. Whoever's playing the classical music, as it is, can you mute it?
Okay.
So what I was saying was thank you, and thank you to the Enforcement Division. I know this is the busiest time for you folks and over the next couple of years, so appreciate all of your efforts.
One question. I apologize for the interlude there. That was me. And I can't mute it without muting me. It's kind of difficult. I have to figure out how to do that. I just wanted to mention that as I was, reading the disclosures on television commercials and whatnot, and also in print material, it seems like we have a little more work to do in committee names. As an example, in Prop 22, from all the information I can discern, all the money's coming from 2 companies, maybe 3. But the committee name is like 3 lines long, and it mentions all the good polling labels that would help, pass the measure, but have nothing to do with the 3 companies that are sponsoring it. And it's not the only one, it's just an example. So I know we've been delving into this issue over the last year, and I think we've got more work to do. I guess that's not really a question. I apologize.
Those are the best questions.
Questions or comments. It's all right, Commissioner. Thank you, Commissioner Hatch. Any other commissioners have questions or comments for Ms. West? All right. Thank you, Ms. West. Appreciate it. Go ahead and go to the Legal Division report. Mr. Bainbridge.
Yeah, similar to enforcement, we're busy giving advice. You see the numbers there, so I won't repeat them, but lots of telephone calls and emails coming in, last-minute questions about filing obligations. We had a public comment earlier requesting additional webinars. I just want to point out we have a number scheduled, especially after the election. We do a lot of SEI trainings for the people who now get to file SEIs. Congratulations on winning office. And we also have video tutorials available. So those aren't live, but they do explore a number of different topics. So if there's a webinar if there isn't a webinar that fits what you're looking for, you might also take a look at the video tutorials. You don't get live interaction, but you get the information. The other thing I'd point out is we have the cost of living adjustment regulation up for next month. I mention it because it's not on the original schedule from the beginning of the year for regulations, and it doesn't go up for pre-notice because it's just doing math. But it's what we do every 2 years to adjust the contribution limits and the gift limit. So I just wanted to point to that since it hasn't been, it wasn't on the original reg calendar. And with that, that's all I have.
Thank you, Mr. Bainbridge, and let me say thank you to you and your staff. I know the advice lines and public outreach and education, those folks are very busy leading up to the election. So thank you for all of your hard work and your team's hard work. Commissioner Hatch, I see you raising your hand.
Yes, thank you. I just wanted to highlight Mr. Bainbridge continuing to track the 1090 letters. I appreciate that. It's, I find that helpful. And it was, I'm scrolling back here. Since the litigation that's outstanding is, it says in here that it's going to, hearing's going to be in November. I can't find the site. November 6th. Is that still going to happen? Or if so, they do that virtually or?
Yeah, that's what it is still on calendar. My understanding is they do it virtually over some Zoom or something similar with the judge in Los Angeles.
Is that something that we could, members of the public can watch? You know?
I don't know. I'll find that out for you and send you an email about that. I'm not sure. I'll have to check with our attorney on that. I think the courts are kind of figuring this out as they go. So.
Okay. Thank you. That's all I had, and thank you for your report.
Thank you, Commissioner Hatch. Any other commissioners?
Mr. Chair, if I might, I couldn't quite hear Commissioner Hatch. What hearing was referenced that may require our virtual attendance?
Well, it doesn't require our attendance, but I'm interested to watch the procedure on the Los Angeles County Superior Court, on the CSAC and School Boards Association litigation. And it's in this report under pending litigation on page 7, I think, of the document.
Okay, got it. Thank you.
All right. Thank you, Mr. Bainbridge. Appreciate it. Go ahead and move now to Chief Administration Hahn for our Administration and Technology Division update. Ms. Hahn.
Good afternoon, Chair and Commissioner. I would like to provide a project update. Staff presented projects that received the Commissioner approval back in August Commission meeting. The first project is document security on the Fppc website. So staff has converted most of the work document on the advice letter into a PDF document on our website. And then the second is we have acquired software license to provide to staff to do the security protection for enforcement stipulations. And then so staff is trained to do that before they post the stipulation going forward. And then the second project that we got approval on was the website tracking metrics. So staff also acquire license and then have been instructed to schedule a quarterly report to review those data and then to share among staff of a data matrix. And then the last but not the least, back in September, I provided an update on the SCI filing, the Form 700, as you know, all may know. So originally, our deadline's on April 1st. We extended to July 1st. And when I provided the update last month, there was 400 plus that had not filed their Form 700 annual. And as of this past Monday, there are approximately 350 left that still have not filed. So we are referring them to, we have been referring them and we will continue to refer them to enforcement divisions for non-filer.
All right. Thank you, Ms. Hahn, and thank you to your staff. I know just like everyone else, you guys are very busy this time of year, so appreciate it.
If you indulge me, I would like to thank my SCI unit staff for all the hard work they've done in the last 6 months, dealing with all the non-filing, the filings, and as well as my admin staff. The project I gave you an update on require a lot of back-end work of my admin staff, not only IT, but also admin, because they have to do a lot of purchases.
I'd like to comment, Ms. Hahn. Thank you very much for having your staff follow up. It started with a 30-minute meeting we had last year. So I really appreciate the countless hours that were put in by you and your staff to follow up on those projects. I do have one question, and you may not have the answer right now, but of the 350 Form 700s that have not been filed, what percentage is that of the total number that have been filed, or 350 out of how many total the Form 700s were filed?
So you're challenging my math calculation.
Well, I know for sure it's better than mine.
So the ones that we receive here is approximately 25,000. So there's 350 that have not filed out of the 25,000 universe.
So 350 out of 25,000.
Yes.
Okay,
I don't exactly know the decimal point, but
that's close enough. That gives me a sense, and the public a sense. But thank you. And like I said, your math calculations will be much better than mine. So thank you.
Thank you.
Thank you, Commissioner Wilson and Ms. Hahn. Do other commissioners have questions or comments for Ms. Hahn? Hearing none. Thank you, Ms. Hahn. And last but not least, welcome back, Ms. West, in your capacity as Executive Director for your Executive Director report.
So now you get Executive Director information. So we have started our Chief of Enforcement search, and we have applications. We have interviews in the coming weeks, and we hope to be able to give you an update at the November commission meeting, hopefully some success. I'm double crossed fingers on that. And then the Digital Transparency Task Force, we're getting back up and running. It's with all the COVID restrictions and everything, the lockdown that happened, we paused for a moment, but we have a planning meeting tomorrow, and then we're hoping to have another Digital Transparency Task Force meeting in late November. So that's the goal, is hopefully the experience from the election will be able to translate into ideas for research and proposals from the Digital Transparency Task Force on how to improve the disclosures on ads. That's it.
All right. Thank you, Ms. West, and be remiss to not recognize all the work you're doing in this busiest time of our year in your dual capacity as both Executive Director and Chief of Enforcement. So thank you for all of your hard work. Do other commissioners have questions, comments for Ms. West? Commissioner Hatch?
Delina, are you satisfied with the quality of the pool of applicants that you have for the replacement?
Well, I'm at least satisfied with some.
Oh, I'm sorry. I meant that you felt you had an adequate pool.
Yeah, I think it's a smaller pool than I had anticipated, but it's a tough job, so you really have to want it to do it.
Thank you.
I should say it a lot more appealing. It's a great job because you really do get to influence and cause consistency and fairness in elections, and so it's very personally rewarding as a job. So people should apply and want to do that job.
Much better. Any other questions or comments for Ms. West? Hearing and seeing none. Is there any public comment on item 16 in our executive staff reports? Hearing none. Then proceed to item 17. These are commissioner comments and proposed future agenda items. Commissioners have anything they wish to speak to in item 17? All right, well then I will take the opportunity to mention two things. First and foremost, I think we probably can't say this enough. We have an election coming up. Everybody should take the opportunity and please make your voice heard, get out and vote. We have mail ballots. We have various ways of doing that here in California. So I cannot urge you strongly enough. Please get out and vote. The second thing is a little bit more mundane, but important to our lives, and that is, as I think everybody knows, the Secretary of State's office is undergoing the process of updating and changing the Cal Access system. So it's the Cal Access Replacement System, or CARS, as we call it internally. So as that process moves down the pipe, my understanding is it's a February target date for rollout of that new system. I just wanted to invite members of the regulated community, members of the public in general, if there are areas of our regulations that you think need to be updated or will be affected by that new system as we understand it today, please contact our office, Mr. Bainbridge, and give us your feedback. That's something that we're in the process of developing our regulatory calendar for next year. And so knowing sooner rather than later what types of changes to our regulation are necessary to conform to the new Cal Access replacement system is important information for us. So hopefully in the next few months we'll be receiving that type of feedback. Other than that, I don't have anything further. Commissioner Hatch?
Since you raised the election process, I just would compliment the Secretary of State's office on providing this new system, where I, as a mail-in voter, can, in a very easy process, opt into notification. So I got a notification just 2 days ago that said, received my ballot and it will be counted. That was very reassuring. I know there's been a lot of misinformation out there about the trustworthiness of mail-in ballots, but that certainly helps ease the worries of mere mortals like myself.
Thanks, Commissioner Hatch. I agree. All right. If there are no further comments or questions, Commissioner Cardenas?
Chair, if I might.
Please.
Another rather mundane matter compared with the imploring of our fellow citizens to go out there and participate in the sacred democratic process. But back to the mundane. Earlier, Commissioner Hatch reminded me that his term is soon ending, and of course, so is mine. If we were to both leave, let me just get to my question. In a situation like this, does someone at the commission notify the relevant appointing authority that their appointee's term is up? How mechanically does that work?
Well, the short answer is yes. The staff here at the commission, particularly the executive director and the chair, are in communication with the appointing powers for the various seats for which there are vacancies currently and which there will be in the future. And so we're monitoring that. We obviously don't have the power to appoint somebody, but it's on our radar and we're in communication with folks.
Yeah. Thank you very much.
Thank you. All right. Do we have a motion to adjourn?
So moved.
So moved to adjourn.
Second.
Right. Motion by Commissioner Wilson. Second, I think Commissioner Cardenas got it in there. Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Wilson?
Aye.
Chair Manich?
Aye.
The motion passes.
Thank you, everyone. Have a good day.
Can't figure out how to. Oh, leave.